Development Law, specializing in global trade and policy with over 20 years of cross-border experience, advanced sustainable development across Africa. Her work sits at the intersection of trade, ESG, governance, women economic empowerment, and green job creation. As manager of the Chartered Institute of Arbitrators Rwanda branch and founder of Awasun Global Consulting Group, she leads national ADR capacity building institutions, strengthening and youth women development initiative in Rwanda and across East Africa. Also, she champions responsible investments, EFCFTA-driven market access, and climate smart enterprise development aligned with African Union's Agenda 2063. Ms. Mispa's expertise spans circular economic systems, renewable energy value chain, green finance mobilization, law, ADR, and cross-border supply chain, scaling position women not just as beneficiaries of sustainability, but as leader of Africa's green transformation. The expert's perspective she brings connects policy reforms, trade integration, and ESG compliance to practical pathways for development jobs, demonstrating how sustainable trade and women-led enterprise can power inclusive economic growth continents um, continents-wide. Right, so that's Ms. Mispa. We are happy to have you join us. Thank you so much, Ma, for being here. Our next mentor we are expecting in today's class is Ms. Jennifer China Soku Anehe. Sorry, Ma, if I didn't get the pronunciation of your name very well. Mrs. Jennifer is um, Mrs. Jennifer is a distinguished legal practitioner and certified ADR practitioner with over 6 years of diverse law experience spanning dispute resolution, litigation, corporate advisory, and human rights advocacy. She holds LLB, that is a law degree from Abruz Ali University, Ekuma, and a BL from the Nigerian Law School, Lagos campus. She is a committed member of the Nigerian Bar. Jennifer is a certified mediator with the Settlement House ADR Training Institute. She also received professional training in arbitration with Chartered Institute of Arbitration, UK Nigerian branch, further strengthening her expertise in structured dispute resolution mechanism. Her legal practice covers a broad spectrum, including alternative dispute resolution and mediation, corporate and commercial law, criminal and civil litigation, election, petition and electoral law, human rights law, and property law practice. This multidisciplinary exposure enables her to mentor ADR mentees with practical insights into how mediation and arbitration intersect with complex legal realities. Um, we can't really go through all of our profile, but thank you so much, Ms. Jennifer, for joining us. We are happy to have you on call. Next, we have Mr. Benjamin Ishaya Shekari. Mr. Benjamin Ishaya is also commonly known as Ben Shekari. Ben Shekari is an engineer, certified mediator, certified counselor, certified goal setter, trauma healing caregiver, AI and digital system strategist, certified project manager, certified thinker, speaker. Ben Shekari is a multidisciplinary professional with a unique blend of engineering expertise, conflict resolution experience, counseling, counseling background, and digital innovation leadership. He holds a BTech in engineering from Abubakar Tafawa Balewa University, Bauchi. His analytical engineering foundation strengthens his structured thinking, system designed approach, and solution-oriented mindset in both institutional and human-centered engagement. Ben is a certified mediator with the Settlement House ADR Training Institute and Kaduna State Multi-Door Courthouse, Kaduna, where he has been trained in alternative dispute resolution frameworks, structured dialogues, and conflict de-escalation methodologies. Thank you so much, Mr. Benjamin. We are happy to have you on board. Our next mentor is Ms. Queen Esther Ozioma Emmanuel. Queen Esther Ozioma Emmanuel is a dynamic mediation mentor, an alternative dispute resolution advocate with strong practice exposure in conflict management, legal leadership, and structured dispute resolution system. Her works reflect a deep commitment to promoting dialogue-driven solutions and equipping emerging professionals with the skills required for effective and ethical mediation practice. She served as executive assistant to the executive director of the Settlement House Training Institute, Shati, where she plays a strategic role in executive administration, institutional coordination, and the advancement of ADR initiative. As an associate of Shati, she contributes to mediation training programs, support the development of future ADR practitioners. Thank you so much, Ms. Queen Esther, for joining. We are happy to have you on call. Next mentor is Ms. Deborah Megali, dynamic and multifaceted professional whose work spans mediation, leadership development, education, faith-based service, entrepreneurship, and strategic communication. She brings a holistic and people-centered approach to conflict resolution grounded in empathy, emotional intelligence, and principled engagement. She is a certified mediator with structured training and practical insights in alternative dispute resolution. Her mediation approach focuses on fostering understanding, rebuilding communication, and guiding parties towards mutual beneficial and sustainable outcomes. With her background in trauma healing. As a trauma healing specialist and emotional intelligence coach, she is particularly attentive to emotional dynamics of conflicts, creating safe space where individuals can openly explore concerns and move towards resolution. Thank you so much, Mrs. Deborah, for joining. We are happy to have you in session. Another mentor we would have in class. So we have to run through our list of mentors. And it is very Khadija Kabir Shehu. Ms. Khadija Kabir Shehu is a dedicated legal practitioner and an experienced mediator with over 8 years of professional practice in mediation. She currently serves as the mediator with the Kaduna State Multi-Door Court House, where she plays important role in facilitating amicable dispute resolution and promoting access to justice through alternative dispute resolution mechanisms. She is a proud member of the Institute of Chartered Mediator Conciliators, demonstrating her commitment to maintaining high professionalism standard and advancing her excellence in mediation practice. Khadija obtained her law degree from Bayero University, Kano, and was called to the Nigerian bar in 2015. Since then, she has built a strong reputation for professionalism, integrity, and effective conflict resolution. Our next mentor is Mr. Archie Dabara. Mr. Archie Dabara is a seasoned educator, mentor, and mediation advocate with over 15 years of progressive experience in teaching leadership development and conflict resolution. He brings a multidisciplinary background that integrates science, education, theology, and alternative dispute resolution, equipping him with a well-rounded perspective for mentoring individuals and institutions in mediation practice. He holds a Master's of Technology in Biochemistry and receives foundational and professional training in teaching pedagogy, right? Sorry about my pronunciation, guidance and counseling, alternative dispute resolution advocacy, theology, and life science. His academic and professional journey reflects a deep commitment to human development, ethical leadership, and peaceful conflict engagement. Thank you so much, Mr. Archie, for joining. We are happy to have you on call. I think this is our last mentor. No, not our second to the last mentor that we'll be having in class, Mr. Steven Mbayami
You can skip
Lungu.
Mr.
Okay,
Yes.
okay. So we have also Mr. Joshua Zaka Nyang. Mr. Joshua Zaka is an accomplished jurist, certified mediator, and ADR advocate who brings judicial depth and practical dispute resolution expertise to the development of emerging professionals in alternative dispute resolution. He currently serves as a judge of the Upper Customary Court, Zaria, Kaduna State, where he administers justice with integrity, fairness, and a strong appreciation for cultural sensitivity, sensitive dispute resolution. His judicial experience provides him with a profound understanding of conflict dynamics, procedural of Meduguri and was subsequently called to the Nigeria bar, establishing a strong foundation in legal practice for ascending into the bench. Over the years, he has combined courtroom experience with alternative dispute resolution mechanisms, recognizing the value of mediation and arbitration, promoting timely and sustainable justice. That is our mentor, Mr. Joshua Zaka. We are so happy to have you in class. Okay, we also have Mr. Isaac Asari. Mr. Isaac is a highly respected paralegal, alternative dispute resolution expert, mediator, and peace and security consultant with over a decade of experience in conflict resolution. He is the founder and president of Africa Center for Collaborative Disputes and the Association of Conflict, Peace, and Security Experts in Africa. As a trainer, mediator, negotiator, arbitrator, and paralegal, Isaac has played a pivotal role in shaping ADR practice across Africa, training professionals with business executive, and community leaders to resolve disputes efficiently. His expertise spans family labor, mining, commercial and land disputes, helping individuals, organizations, and institutions achieve amicable and lasting solutions. He is the author of the Commercial Mediation Handbook, which serves as a practical guide for mediators and negotiators. His thoughts leadership has contributed to advancing ADR frameworks and policies across Africa. Last but not least, on our mentors list for today is Mrs. Nyacham Janet. Mrs. Nyacham Janet holds a national diploma in mass communication from Kaduna Polytechnic and a bachelor's degree in mass communication from University of Jos, where she graduated as the second best student in her set, driven by her application. She completed a professional diploma in education, becoming a certified teacher. Additionally, she possesses a diploma in computer application, specializing in MS Word. Her legal experience includes 5 years or as a litigation secretary at FI Salami and Co. And and her current role as a litigation secretary and human resource personnel at NHM and Co., where she has worked since 2017. In her capacity, she has developed expertise in drafting legal documents such as legal processes, sales agreements, deed of assignment, and official letter. Thank you so much, Mark, for joining in. We are happy to have all our mentors on board. Sorry we took so much time reading our profile. It was experience that we do so just so that we can have a sense of the mentors we are going to be having with us throughout the course of this program. So not to waste any further time, I would like to firstly go back to introducing myself. My name is Dennis Williams, and I'll be your moderator for today. So our agenda for today is we'll be taking presentations from mentees first, and then after presentation from mentees, then we would have our mentors come and just generally give their discussion into the topic for today, which is an overview of ADR. So thank you so much, everyone, for joining in. I'm happy to have us all on call. Right, so we'll start, like I said, we'll start with the presentation from the mentees. We have two groups who will be presenting in class today, group one and group two. I hope you guys are ready for us. Sincere apologies to the mentees for the delay in the session, in the start of the session. Please, let's go ahead. Group presenter,
Okay,
try
Mr.
and share
Dennis.
your screen and start your presentation.
Mr. Dennis,
Yes, sir. Yes, sir.
yes. Just a minute. See, I see I needed to recognize the presence of one of our boss who created time to be here with us, Dr. Stevie Daniel. She is a council member of the Settlement House India Training Institute. and the director of the Kaduna State Multi-Law Courthouse. Please, ma'am, if you are here, can you just greet us before we proceed?
Thank you so much. It's a pleasure being here. Thank you for what you're all doing. Thank you to the mentors and to the mentees. We appreciate you all. Thank you.
Thank you so much, ma'am. Thank you. All right, Dennis.
All right, thank you so much, sir, and thank you also, Miss Deborah, Mrs. Deborah. So please, our good presenter for group one, we are waiting for you. Please kindly go ahead, share your screen, and then start your presentation. You can take your presentation for the next 10 minutes, and then we'll head over to the next group. After their presentation is done, then we'll hand over back to the mentors. So good presenter for group one, please, we are waiting for you. Hello, our presenter for group one. Please, we are waiting for you. Okay, if the presenter is to presenter, please let's try to do that as quick as possible so that we try to save time. We've already spent quite a lot of time. Okay, all right. Mr. Dominion, are you with us?
Good evening, sir. Can you hear me? Good evening, sir. Can you hear me?
Yes, we can. Yes, sir, we can hear you. Yes, we can hear you, Dominion.
All right, sir. Good evening, everyone. I am Dominion Nigeria Tutu, and I'll be presenting for Group 1. And I want to confirm, please, if we can all see my screen.
Yes, we can see your screen.
All right. So, my topic on behalf of Group 1 is understanding alternative dispute resolution and its methods. And by way of introduction, I would like to say that the human society is premised on social interaction and not just social interaction alone, commercial interaction, personal interaction, legal interaction, and all kinds of interaction. And proportional to these interactions, there are conflicting interests are bound to come in, misunderstandings are going to, all kind of disputes are going to arise. And for us to have dispute resolution systems, dispute resolution methods to resolve these issues and any conflicting interests that may arise due to various interactions. And traditionally, there has been some dispute resolution mechanisms such as litigation and the customary way of resolving dispute, but they have been not, the effectiveness has not been established compared to how it's supposed to be. Hence, ADR comes into place. That's the alternative dispute resolution, as it was introduced to primarily provide systems of resolution of conflicts without litigation or um, any traditional system of resolving dispute. Okay, and the purpose of ADR, or alternative dispute resolution, is to cover for the shortcomings of litigation or any traditional dispute resolution system due to the long, lengthy process and the financial cost and the duration of time that it takes before dispute can be resolved. Resolution came in to bridge the gap and then accelerate settlement and still maintain cordial relationship between parties. And ADR, alternative dispute resolution, consists of many systems or many processes of resolving disputes, but we'll be talking about four major types today. That includes negotiation, mediation, conciliation, and arbitration. And there are other types of processes that are used to resolve dispute. That includes fact finding and many trials. But we'll be focusing on this for today's presentation. Now, when we talk about negotiation, negotiation is one of the first steps is a foundational step in resolving dispute, whereby the parties come together to communicate directly and try to settle their conflict without the interference of the third parties. And it is a voluntary, informal, and non-binding way of resolving disputes, such that the decisions are not binding. The parties are not obligated to stay true to the process. They can opt out if they are not interested. So, and there are two key concepts that should be involved, that are involved or that can be attributed to negotiation. That is uh, the best alternative, to a negotiated agreement, and that also known as partner, and the worst alternative to a negotiated uh, agreement. So I will quickly explain what the partner and the partner is about. So the partner focuses on the advantageous course of action that a party can take if the negotiation fails, or if it can't enter into a settlement, if it can't enter into an agreement. So what it focuses on is the most advantageous course. For example, okay, if the deal doesn't work out for me, what is my best realistic option? So, and now the worst alternative to a negotiated agreement is just the party looking at the worst possible outcome that can happen if the negotiation fails, or if it can't reach an agreement that, okay, if this negotiation doesn't work for me, what is the worst realistic thing that can happen? Now, these two things I've stated are important in negotiation because they help to avoid overconfidence, to evaluate litigation risk, and to ensure that the parties make rational settlement decisions. And I will give an illustration to back this up. That is, for example, a client and a contractor. A contractor who builds houses, and he builds a house for his client, a house worth 5 million naira, for example. The house is worth 5 million naira, and the client refuses to pay the 5 million naira, claiming that there is poor. Why they try to resolve the dispute among themselves during negotiation, the party that's a contractor now, is best advantageous course of action is, for example, to sue the client to court. And if he's successful in court, the court may order full payment for plus interest rather. And his worst realistic option is if, for example, the court eventually actually finds defects in his work. The contractor may lose the case and eventually spend heavily on legal fees and wastage of his time. And on the client side, his best option, for example, would be to defend the case in court and possibly pay a reduced amount if the defect he's claiming are actually proven. And then his worst option would be that, okay, if no defect is found, if he can't prove his case, the court will order full payment plus damages, and he will have to pay legal costs. Okay, so but how this will work is that if after negotiation and they've looked at both sides and they discover, okay, if the contractor is eventually offered 4 million and he compares it to his court action and discovers that, okay, if going to court is risky in the sense that it's slow and it's more expensive, we'll just take the 4 million as thinking, hoping that it is seen that it is better than if falling for is for the worst possible outcome. So, and the stages involved in negotiation include the preparation, the discussion stage, the bargaining stage, and the closing stage. So, the preparation stage is where the parties where they define their objective before going into negotiation, they identify the issues and they assess the strength and weakness of the issue they want to discuss. And then the discussion stage is where they meet, where they prepare the ground rules of their negotiation, and they share their initial positions. So and they clarify issues such that the discussion stage is where the underlying issue, the underlying interest is identified, and the bargaining stage is where counter offers are being made in a bid to achieve settlement, where the flexibilities involved are put in place, and to see how can there be a compromise, can there be is there a way I can come in? Well, this one can how the parties can meet at a consensus at Eden, and then the closing stage is the um, where the agreement has been made, a settlement has been placed, and then they clarify whatever issues need to be clarified. They get to a mutual understanding and they sign off the agreement. So basically, that's what negotiation is about. And when we're talking about mediation, so mediation is a dispute resolution process where the a neutral third party comes into the scene to listen to the two parties, okay, and then consider their positions, look at the dispute, and try to move the parties towards settling their dispute. Okay, the the mediator is not in the scene, is not in the dispute resolution phase to impose any decision on them. He, and it comes in when negotiation has not been successful by the party. So the mediator is not coming in to act as a judge to impose a decision or determine who is right or wrong. It's just there to facilitate communication, clarify misunderstanding, and help the parties to identify underlying interest. Okay, so mediation also is voluntary. It's not mandatory on the parties if an agreement has not been reached. So is the parties can opt out before settlement occur. So, but if after the phase of negotiation an agreement is reached and documented and signed by the parties, okay, it won't be difficult to opt out because at that point the agreement will be binding on them. And then negotiation may also be divided into three phases. That's the facilitative mediation, the evaluative mediation, and the transformative mediation. I'll just briefly explain what each is about. Under facilitative mediation, the mediator is a neutral facilitator, and is not there to give his opinion. Rather, it's just there to identify the underlying interest of the parties and focus on how there can be a voluntary settlement, a voluntary mutually agreed settlement. Okay, so but under the evaluative mediation, the mediator has more active role to play in the dispute resolution process, such that he he may suggest possible outcomes and then try to predict what the court will do should in case the matter escalates to go to court, to open the eyes of the parties to see that, oh, okay, if you guys can't resolve and this matter gets to court, this is what is likely to happen, and focus on and prepare them for a realistic settlement. And then a transformative mediation is more or less like improving the relationship factor between the parties than reaching an agreement, because The mediator tries to encourage mutual understanding. He tries to promote better communication between the parties if he discovers that communication is the issue. And then the settlement is secondary to the relationship being repaired in the dispute process. Okay, and transformative is a mediation phase that is useful in family disputes, in a communal dispute, or in workplace dispute. And when we look at the stages, it also has its own stage that there's a preparation, the opening, the issues, the agreement, and the closing stage. So preparation is where the parties agree to meet, the mediator is appointed, the date and the venue for the mediation is fixed. That's what the preparation stage is all about. And then the opening stage is where the mediator introduces himself, he explains the mediation process to them, and the ground rules for the dispute resolution are set, and the issues are clarified. And the issue stage is where the the parties explain their issues. Okay, they explain what each person wants, and then the mediator is able to identify what is the main issue, identify their underlying interests, and bring them to a common ground. Okay, and the agreement stage is I would call it the resolution stage. This is where the a consensus has been reached, and then all options are explored and evaluated to reach a consensus, and the agreement is written down. The settlement is written down and signed by the parties, and the closing stage is where the mediator reviews the terms of the agreement and confirms that the parties understand what they have settled on, and then formally close the um, the mediation process. So conciliation is another alternative dispute resolution process whereby a neutral third party is also invited to the dispute resolution to settle conflict. Okay, and the conciliator plays a more active role than the mediator. So conciliation has more hands than mediation, and what is therefore is to suggest possible solutions and settlement terms. And the process is a voluntary process, as stated earlier. It's confidential and flexible, such that it also seeks to preserve the relationship between the parties, and it is request-driven, distinct from mediation's facilitative style. So arbitration is another alternative dispute resolution process, and it's a quasi-judicial process where a neutral third party, that is an arbitrator, is enters the dispute resolution process, hears the issue, and makes a decision that is binding on the parties. And for example, in arbitration, the arbitrator may be one, it may be two, it may be three. But for example, for the sake of not being partial, a party can bring an arbitrator, the other party comes with the arbitrator, and then there's a neutral one, none from their sides, to ensure that the matter is judged, is handled without partiality. So the arbitrator hears the issue and hears the issues and the interest and makes a decision that is binding on them, which is also known as the arbitration award rather. Okay, and it's an enforceable award, and it's private, flexible, and fast, and is ideal for commercial transactions, for international dispute. And in arbitration, the arbitrator acts in an analogous capacity, just like a judge, okay, such that he hears the issue, determines the evidence that can be adduced, and gives a decision. And I'll move to the differences between ADR and litigation. So, and I would streamline the differences to five major divisions, such that in the formalities of the alternative dispute resolution process, the formality is less formal. Okay, why litigation is highly formal, such that litigation is full of procedures, is full of various measures that must be taken, various processes, and these formalities in litigation makes it time consuming than alternative dispute resolution. And the nature of process, um, litigation is adversarial in nature, while ADR is non-adversarial and consensual. So litigation is adversarial in nature such that it is confrontational in approach. So it's more or less like a party is bringing another party to confront the party. Most times there is a saying that two people go to court as friends, but they live as enemies. So rather than settling the dispute is not settled to the relationship factor. It's just settled on the basis. So, but ADR is consensual, and it because it requires the party cooperating together and working together to reach a mutual solution. And then the decision-making authority is another factor that is a, that that makes a difference between ADR and litigation, such that the the decision-making factor for litigation is the judge or the justice of the court, while in ADR, it depends on the process, it depends on the dispute resolution process that is adopted by the parties. It may be an arbitrator, it may not be an arbitrator, it may be such that the dispute is settled amicably between the parties. And the rules of evidence are flexible. Okay, there's alternative dispute resolution gives room for flexibility, while litigation follows strict application of rules. So there is a strict application of rules which may not be in the interest of justice to the matter at hand. So, but HDR gives room for flexibility rather than ensuring strict application of rules. And then the right of appeal is that under litigation, it is automatic. Once a decision has been made, the the aggrieved party has the right to appeal immediately. And that shows that the dispute has not actually been resolved. Rather than being resolved, it's just escalating into more and more things. So, but in ADR, it is limited. Why? The parties work together hand in hand through the flexibility of rules and measures and procedures. They are able to meet at a common ground and settle whatever dispute is before them. Now, the benefit of HDR is such that there is a faster resolution of conflicts. For example, litigation, a dispute that happened in 2025 might end up being resolved in 2027 due to adjournment and various lengthy process in litigation. But in HDR, the, the issue is resolved faster and on time. And then there's the lower cost. There's a lower cost because parties won't spend as much as they will spend if they take the matter to court. And then alternative dispute resolution gives room for more flexibility, and confidentiality is also guaranteed in alternative dispute resolution compared to litigation. And there is no bias because, for example, the presence of the third party, that's in person of the mediator or the conciliator or the arbitrator, gives room for impartiality because it looks at it can understand the dispute side from the party A and party B, see who is wrong and be able to give produce a common ground for them to meet, and there is less friction. Okay, so examples of disputes that are best suited for ADR, we have contract disputes, we have family disputes, and employment disputes between employees in a workspace or between the boss and the employee. We have business disputes that we can trace out to partnership disputes. And then we have consumer disputes, real estate disputes, intellectual property disputes, where arbitrator can be used to settle such disputes. We have environmental and public policy disputes, and we have the personal injury dispute. So alternative dispute resolution gives room for not just one kind of dispute, but for various kinds of dispute that can be resolved amicably. Thank you.
All right, thank you very much, Dominion, for a wonderful presentation from you. Well done to you and to your team for putting together that presentation. The mentors will give feedback to your presentation after you are done. So well done once again. Please, can we have the group presenter for group two come up and make your presentation? Please try and make it as fast as possible so that we can have an extensive discussion from the side of the mentors. Do we have the presenter for group two in us? Please, can you kindly come up and make your presentation? We are waiting for you. Thank you very much.
Okay. Good evening, sir. Let me share my screen.
Thank you very much, Mr. Emmanuel.
And please, those that are
Good evening,
those that are
everyone.
presenting, if they can put on their camera, that would be nice.
I don't think I can put on my camera with my phone while sharing my screen. But can everyone see my screen now?
Go ahead.
Okay, so
Yes,
good evening,
we can
everyone.
see your screen. Please.
Yeah, good evening, everyone. My name is Emmanuel, and I'll be presenting for Group 2. Our topic is ADR in practice and legal framework. Like earlier said by the presenter for Group 1, ADR refers to mechanism or method that are used to resolve disputes without resorting to formal litigation. Without going to the four corners of a courtroom, disputes can be resolved. So instead of going through long, expensive, and adversarial processes, we could resolve disputes through different mechanisms such as arbitration, conciliation, mediation, and negotiation. So ADR has become an important aspect of the legal framework in Nigeria. It has helped resolve disputes. It has helped the court congestion, a faster and better way of resolving disputes with various plenty means. So we have five contents which we'll be going through, which is how ADR works in real life dispute resolution, ADR processes, its roles in business and community conflict resolution, the overview of ADR legal framework in Nigeria, and also a case study, which is a land dispute resolved through ADR. So let's begin now. So how ADR works in real life dispute resolution. Like I said earlier, we have four different types of mechanisms, which are negotiation, mediation, conciliation, and arbitration. So negotiation is the first mechanism or the first method of ADR. This is the most commonly used method. This involves both parties resolving their disputes by themselves without any neutral third party. Both parties seek to reach a compromise to achieve that resolution. So both parties hereby present their arguments, present their faults, their business, and they seek to strike to a resolution. So in negotiation, both parties communicate immediately to each other to work things out. And negotiation takes part in businesses which seek to settle contract disputes. And we have mediation. So mediation is when an agreement is reached. Mediation happens between both parties, and there is a neutral third
Just
party
a
involved.
minute.
Yes?
Mr. Emmanuel, a minute.
Okay.
Dennis,
Yes, sir.
can you help him share the screen so that he can concentrate? It seems his network is bad, and to share screen may be affecting it.
Sir, his network, his voice is quite clear from my own end. I don't know, maybe it's from your end, sir, that you can't properly hear him.
Okay. Then go ahead. Let's see.
Okay. So I was going to the second mechanism of alternative dispute resolution. I said we have mediation. So mediation is a formal ADR, is part of the ADR processes in which both parties seek to resolve their dispute with the help of a neutral third party called a mediator. In mediation, the mediator performs a role of facilitating communication between both parties. So the mediator doesn't propose a solution to both parties, but it helps them to seek or see a resolution. So in mediation, when an agreement is reached, the party formalize it in writing. Depending on the legal framework, such an agreement may be enforceable and recognized as a contract. For example, in Nigeria, mediation settlements can be recognized and enforced as contracts under the Arbitration and Mediation Act of 2003. Then onto the third mechanism or method, we have conciliation. Conciliation is similar to mediation, but in conciliation, the conciliator performs a more active role in the sense that the conciliator proposes a solution to both parties. The conciliator seeks to facilitate understanding between them, but the conciliator offers his expertise in reaching a resolution. Then lastly, we have arbitration. Arbitration is a formal process of alternative dispute resolution. In arbitration, both parties present their matter before an arbitrator or arbitrators. The arbitrator listens to their evidence, listens to their discussion and arguments, and gives a decision. And such decision given by the arbitrator or arbitrators is called an award, and the award is binding on both parties. So I believe we now understand the different mechanisms or method of alternative dispute resolution. So moving on to its processes, each mechanism of resolving disputes have its own process. And we'll be going through negotiation first. So in matters of negotiation, both parties, first, they prepare by understanding the dispute and setting goals between both of them. They agree on ground rules like the schedule and time, where to meet, what they'll be discussing, how to reach a resolution, exchange of offers and counter offers. While in mediation, Section 70 of the AMA Act provides that mediation begins via a written agreement, defining its scope with formal notice to parties and the mediator. So in mediation, the process begins by parties agreeing to mediate, and most times or sometimes a court orders for the mediation process to begin between or to commence between both parties before they resort to litigation. So a neutral mediator is chosen, and it is important for the mediator to be neutral. If the mediator is biased, it will compromise the entire mediation process itself. So they have a preliminary meeting to set rules and confidentiality. Both parties, they present their issue and the mediator help them facilitate understanding. Then to the third mechanism is called, which is conciliation. So in conciliation, like I said earlier, which is similar to mediation, both parties first send a written request to begin. They choose a neutral conciliator, and this conciliator meets with both parties, suggesting solutions. The key word between mediation and conciliation is the conciliator in a conciliation process suggests solution, while in mediation, the mediator just seeks to facilitate understanding between them. So while continuing, the conciliator, they draft the agreement terms and both parties end the dispute if they accept, and if they do not, the decision or the proposition made by the conciliator is not binding on them. Then we have the last mechanism which we'll be discussing, which is the arbitration. So the arbitration process begins with a written notice of arbitration from the claimant to the respondents, detailing the disputes, arbitration agreements, and relief sought after by both parties. So the notice of arbitration begins the case, arbitrators are appointed, a timetable is set, parties exchange evidence, and when the arbitrators or arbitrator have listened to all the evidence and arguments, the arbitrator gives a decision which is called an award. This award is binding on both parties and it is enforced by the court as a judgment. Then we'll be talking about the role of ADR in business and community conflict resolution. I'll be talking about the importance of ADR. What does ADR do? How do we implement the ideas of ADR? Now, I'm going to be talking about the actualization of ADR in our community, in our business. So the role of ADR in business conflict is one, resolving disputes faster than courts. The case in which we'll be talking about in the case study is the case of Ibime Water Trench. This case now was about a dispute between regions, and this dispute took years until mediation came in place to resolve this dispute. This is trying to say in business conflicts, a land matter or business matter could go on for years, 10 years, 15 years. While with any of the ADL mechanism, it is faster and it cuts down legal costs. There's no payment of any legal fees, transportation is not being present, no printing of papers going here and there. So it cut down legal fee. Another benefit is it keeps matters private to protect secret and reputation. So the role of ADR is there's confidentiality, which is one of the key core and key values of using ADR. So matters are not being made for the public. There's no public trial or any of the sorts. And also it lets parties choose where and how to resolve their disputes. Parties are given the freedom of setting favorable time, favorable schedule for them not being given a time by the court to just show up. And also, it keeps business relationship intact. So parties preserve the relationship, their mutual connection between both of them. It is not tarnished by the decision. So now that's in the business aspect. Why in the community aspect? How does ADR work? ADR encourages dialogue and reconciliation. ADR does not seek to tear apart both parties. It does not seek to destroy the relationship, but instead it seeks to facilitate understanding and communication between both parties. So it encourages dialogue, speaking between both parties to reach a resolution. It also uses trusted traditional or spiritual mediators. Lawyers are not being used. Unfamiliar faces are not being used. Instead, the traditional rulers, the traditional leaders, they are being used as mediator to reach a resolution. And it reduces the number of cases court need to handle. As we all know, the number of cases being presented to the court daily is a lot, and not everything has even been discussed or being settled every day. So if there's another alternative method in which both parties could resolve their issue without going to the courts and reaching a compromise which is suitable to both parties, we all know that is welcome. And also it creates solution where everyone wins, promoting peace. In ADL, there is no loser. They are both winners. So ADL seeks to promote a win-win outcome, which is accessible to everybody. And the aspect of community conflicts, ADL is accessible to rural communities. It is not secluded to any party. Then its overall role, ADL saves times and money. It promotes cooperation, improves access to justice, and supports social and economic balance. ADL seeks to establish financial and social balance in the community to save time and money. Instead of going to the courts, the expenses, legal fees, or anything, ADL seeks to cut that off. And to the fourth context, which is overview of ADL legal framework in Nigeria. As we have said now, we'll talk about its importance, we'll talk about how the actualization process happens and everything. But now we need a legal framework like anything else. Is there a legal backing for these processes? How does it happen? Which laws or acts are backing it? So first, we have the Arbitration and Mediation Act 2023. So Nigeria formerly used Arbitration and Conciliation Act of 2004, but this act did not fully recognize mediation. It only recognized conciliation and arbitration. However, due to the Act's failure in meeting the demands of modern commerce and increasing digitalization of the legal practice, the Arbitration and Mediation Act of 2023 was created. So this act officially recognized mediation, recognized arbitration, and conciliation. Then we have the Rule of Professional Conduct 2023. This rule requires lawyers to inform the clients about their options. Clients are made aware of the options available to them. They are made aware of negotiation, conciliation, mediation, and arbitration. So we have the Court of Appeal ADR program. The Court of Appeal ADR program, under the 2021 Court of Appeal rules, encourages appeal settlements. The court itself, most times, could recommend both parties to resolve their disputes through mediation or through conciliation. If both parties are not satisfied by the judgment and do not reach a compromise, they could thereby resort back to the courts. We have the State High Court rules also of 2019. The High Court rules of state in Nigeria incorporate provisions that promote the use of ADR as part of the processes of resolving disagreements. So these courts, like the High Court rules, like the one of 2019, showcase cases for ADR and refers them. That means parties which have disputes could actually go through ADR means and mechanism to resolve their disputes. And lastly, we have Lagos Multi-Door Courthouse. So Lagos Multi-Door Courthouse was established in 2002 through a public-private partnership with support of the Lagos State Judiciary. So the court-related center provides mediation, arbitration, and conciliation to both parties. So this legal framework in Nigeria backs the ADR process. It makes available to parties that they have different variations of options available to them to resolve their disputes. So before proceeding to the last content of the day, I just want to get the feedback if everyone is following and do we understand? Hello?
Yes, we are. Yes, we are
Yes.
following. Sir.
Okay, so to the case study, which is land dispute resolved through ADL. So a land dispute among Ikot, Ida, and Osukedene group in Akwa Ibom State. That is the case that we're going to be looking at now. So this issue was over a parcel of land, and this parcel of land was known as the Ibime Water Trench. So for several years, both communities fought for ownership of the land. In an effort to find a suitable solution, both parties embraced mediation, which is one of the mechanisms of alternative dispute resolution. Through structured negotiation and guided discussions, both parties reached a compromise. They agreed to share the land, save money and time, maintain relationship, and restore peace within the community. So this is just like this is exactly a case study of what ADR does. Instead of violence, promoting violence in the community, instead of the losing of lives of youth, the degrading of the community, pollution and everything, or like a long process in which if this matter is being resorted to the courts, it could take 10 years, it could take 15 years. An ADR process is brought into the picture to resolve this issue. So, and this process of ADR is easily accessible to anyone, to anybody. And I think I should make it aware to everyone that ADR doesn't necessarily mean a formal process in the sense that too much English is not required. Like in the aspect of this community now, we're talking about an indigenous group or community. They are not required to speak all their processing in English or any foreign language that they don't understand. That is why they appoint mediators, which are the traditional rulers. So basically, ADR is trying to tell us ADR is available to everyone, and there are different mechanisms available to each group of people. So if you prefer negotiation, you could go to negotiation process. If you prefer arbitration or conciliation or any other ADR process that's available. So thank you very much for listening, and I hope I've been able to really discuss and divert knowledge to everyone. Thank you.
All right, thank you so much, Mr. Emmanuel.
Yeah.
Well done to you and to your team members for putting together that presentation. Both groups, I would say, did well. So well done to you all. But I think it's not in my place to do the judging since I am not the expert in this field. And we have our experts on ground who would help do due justice to everything you have shared and also share their thoughts on ADR as a whole, on the overview of ADR as a whole. And we'll just be handing over to them for them to do their thing, if I'm permitted to use that word. All right, so I'll be handing over to Mr. Nyacham Nawan, who happens to be the Executive Director of Settlement House ADR Training Institute. Shati, alongside with JIIPCC, are the collaborating organizations that have partnered together to bring this mentorship to you, right? So, Mr. Nyacham, we want to hand the floor over down to you
All
for
right.
your. Yes, sir.
Thank you very much for that, for the coordination and to the mentees and the presenters. Well done. I want to first start by appreciating all of you for putting up this wonderful presentation. And some of the presenters, especially Group 1, presented it as though it's so conversant with the terrain. The presentation was so detailed, to some extent. Permit me to say that at this juncture, we want to have some input, from the mentors. So to that effect, I will be calling some of the mentors here present to be able to give us their inputs. I believe that they have gone through what the mentees have presented in the slides and they have listened to their presentation. The goal of the mentorship, is to see how we can look at encourage the mentees to make some research in groups concerning what they have, what they are supposed to learn, and then come and present it, have someone present it on behalf of the group, after which the mentors will now make their various inputs, looking at maybe some areas where the mentees have maybe they talked about or they looked at, they did not go in depth, or maybe they missed a point, or they needed to make some clarification for the mentees. And after this, the mentees will have the opportunity to ask questions. So before I start, we give honor to whom honor is due. I said initially that we have here we had the privilege of having one of the members of the governing council of Settlement House ADR Training Institute, as well as the director of the Kaduna State Multi-Law Courthouse. May I humbly call on her to maybe say one or two things concerning what she has had, if she is available to do so, before we call other mentees. Honorable Dorcas, if you are here, if you want to
Good
speak
evening,
on.
Good evening, everyone. Once again, unfortunately, my network isn't so good, so it's going on and off. But let me commend the different groups for a job well done. They have done very well. I'm glad to hear everything they said. I must say I have learned a bit from them. So they've done quite well. I'm elated to know that we have such young people that will keep on the good work. Thank you for everything you have said. Thank you for taking out time to do your research. Thank you for beautiful presentation. You have all done very well. Thank you. Thank you, Nancha.
All right. Thank you very much, Honorable Dorcas Levin, for being with us and listening to us. We are very grateful. So, first of all, I want to call on see Nispa. Nispa, are you with us? Mrs. Nispa.
Hi, hi, Michelle. Good evening, everyone.
Good evening.
It's always good to be here.
Thank you for being with us.
Good evening. You're most welcome. It's always good to be here with the mentees and my fellow colleagues, other mentors, to share our thoughts and insight with the the mentees. Group 1 and 2 have done an amazing job. Before I delve into some comments, I want to acknowledge the presence of everyone in the house. I learned we have an honorable in the house. With all due respect, good evening from Kigali, Rwanda.
Thank you.
Despite our busy nature, mentorship is something that is rooted into my ADR DNA. And from the day I joined the profession, it has been so amazing. Senior colleagues have never stopped listening to me or talking to me, so I decided to also give back to the community in Africa. So are these mentees new, or they are still part of the former cohort of 2025, or they are all new for 2026, except for Joseph?
They are new.
They are all new.
Yes.
I know how to address them properly, and okay, they are all new, so I know how to address them properly. So one thing I want to say, each and every day we make great progress on the business of ADR. I call it a business. Last week here, as the manager of SIAB Rwanda branch, we received SIAB Global President Dr. Cesar Pereira, and we had stakeholders engagement where I had to, with my branch EXCOM, honor the courtesy visit with the Chief Justice of Rwanda and so on and so forth. And he said something that was very interesting. INAS or ADR or arbitration or mediation tool that helps in the access to justice, but it is a business. And I agree with him 100% because there is a lot of opportunity in the ADR ecosystem. But we have not yet is it? Yeah, when people talk about monetizing Facebook, monetizing LinkedIn, Instagram, and so on and so forth, monetizing YouTube. Hey, we in the legal space, we are not influencers, we are not content creators. content in ADR and monetize them. Very, very important. So each time I have to talk to the young people, I don't hesitate to let you know the importance of understanding the business of arbitration. So consider you have to understand the basics, the very foundational principles that goes with the business and your person as a practitioner. So if you are here and you know you want to sail through the arbitration practice like some of us, then sit properly, get a glass of water and listen to me. This business, just as you see content creators will take ring lights, whatever they're looking forward, how do they call them? I don't even know again, animations, effects, and so on and so forth, to make their videos be what it is the same thing with arbitration. The mistake I made in the first year of my practice, when I joined the industry back, I first of all heard about arbitration in 2019 while I was in the law school. When I left the law school, before I left, I said, this is my path. This is my career, because I don't like litigation. It's too aggressive. And I'm not a very aggressive person. So choosing this path just aligned with my nature and my person as a human being. I'm someone who hates injustice. So going the route of litigation, I might either die before my time, I might either disrespect a judge just because of injustice. So when I stumbled on arbitration, ADR, mediation, and negotiation, I chose it immediately without even thinking twice. I did my associates in 2019 with the Chartered Institute of Arbitration, UK, under ICAMA, Abuja, Nigeria. And after that, immediately I went into my membership I first of all went back because I work with the executive of my country. I went back in the executive, and when I decided to build my private practice, I entered back in 2022. I went straight into my membership training with the Chartered Institute of Arbitrators. At the same time, the same year, I registered with IMC campus in Germany to do my mediation training. At the same time, I registered with different institutions to do my training to get knowledge. And let me share you my beautiful little stories, my baby steps. I have 2 laptops, I have 2 phones. I will subscribe to different webinars, different mentorship programs, different trainings. And then sometimes they all happen simultaneously, or there is one with few 30 minutes, 45 minutes, or an hour ahead of another one. And sometimes all these 2 laptops are on in front of me. Sometimes these 2 phones are all in front of me, and I am dipping myself into the space of ADR. I wanted to know one thing. Who are the influential persons in the industry? That's one. Who are the people really doing well in the industry? What institutions regulate this practice? What are the laws or the regulations involved in this? Why am I saying this? I've heard from your presentation, both Group 1 and Group 2, you are telling us that this mentorship program is all about ADR. But I didn't hear you tell us about the institutions. I didn't hear you tell us about the laws. I didn't hear you list these things, which are very, very key, because let me tell you, aside some of these theories that we get from our research, get even from ChatGPT today with the use of AI, the reality on ground is totally different. If you truly want to excel in the career, I'm speaking to you as a very seasoned practitioner, as a thought leader that people solicit for. And let me share with you my good news today. I just received my result from the Chartered Institute of Arbitrators as a fellow. I passed my fellow exam today. It has been so exciting and amazing. Being the fellow of the Chartered of Arbitrators is not an easy exam. It's very, very tough. It's intensive to do an award writing exam. So this is me telling you learn about this profession. And there, I subscribe to mentorship programs just like what you are doing by joining the YMG group of the Chartered Institute of Arbitrators, joining the ICCF, that is the ICC. I joined what we call the ITI, that's the International Transnational Arbitration Center in the US. I joined Young ICA, what we call the International Commercial Center for International Arbitration. If you don't know about this body, you don't have to know all about bodies in Nigeria unless you want to limit yourself as a domestic practitioner. You don't have to know only the local laws unless you want to practice only domestic arbitration. I practice domestic and so you have to review. If you really want to talk about all about ADR, I recommend all the mentees, group 1 and 2, you go back and review your slides, do your research on the institutions, both domestic and international. You will review the regulations, both domestic and international. AMA is not enough. Yes, group 2, I heard how you elaborated on the Nigerian Arbitration and Conciliation Act 2004. Yes, it's an act I also studied and I know very well before AMA came in 2023 as an inspiration from the Singapore Convention, which really has a picture, it captures that. And the AMA started since 2016 with negotiations with people I know, some of my senior mentors, Chief Bayo Ojo and some others, who did some great work for us to have AMA today. So AMA 2023, it's a great job. And under the Chartered Institute of Arbitrators, Nigeria jurisdiction is, the CIAB Nigeria branch is the only institution allowed in Africa to do what we call domestic arbitration training because of the dynamics of its arbitration jurisdiction. So this is me telling you that you cannot stand in public to talk to an audience about all about ADR and you don't tell them about these institutions, this regulation, and the process. Okay, so that is why it is a mentorship program. That is why you're a mentee, and that is why we are here for you people as mentors. So I will be making comments on the process. You're supposed to, while on those your slides, you're supposed to elucidate the process of each of those. Yes, you just said the processes in the definitions, but the processes in real life and the way they are under academic, it's totally different, and you're supposed to, make us understand them and let us get your understanding of these processes of mediation process, the processes of negotiation, the processes of conciliation, the processes of arbitration. So process is very key. I would advise you all to still go and research again about the process. And when we talk about process here, we are looking at the procedural analysis and the substantive analysis. We know from our study from Maybe Law School University about contract law, law of evidence and all. But do you know that in arbitration particularly, national laws of evidence doesn't apply in arbitration, but what we call the IBA rules on the taking of evidence. So if you don't research about these institutions, you would not know, because these are basic things that happen in the process of the arbitration. And another thing that is very important, you said it, is confidentiality. And this goes with your personality as an arbitrator, or as a mediator, or as a negotiator or a conciliator. Confidentiality is key. Take special note of that. Neutrality is key, especially in mediation. In arbitration, we'll talk about independence, but in arbitration and mediation or negotiation, we'll talk about neutrality. And something I want to also let you know, negotiation, yes, is between two parties, but you can have the role. Do you know about the role of an advocate in a negotiation? I'll give you homework. Go and research about the role of a negotiation process, okay? The role of an advocate or counsel in mediation process or arbitration process. These are key, these are businesses, these are business opportunities that most people don't understand. Even lawyers today, they resist arbitration mediation because they feel that their business has been taken away from them. No, they still remain as representative, as counsel to the process, and you still take your money. The same way, one thing you have to understand in the process is the same way a case or an issue is supposed to be taken to litigation, and there is a judge that sits on that matter. You have an arbitrator or a mediator. These are all private bodies or private persons adjudicating or mediating or facilitating or evaluating these disputes. When I talk about facilitating and evaluating here, I'm talking under mediation, arbitration. Another thing is communication in the process. All about ADR is communication. All about ADR is dialogue. It is very key to communicate. How you communicate as a mediator. And in your communication, that is where the parties see your neutrality. In your communication to parties in arbitration, that is how the parties see your independence. So you see how communication is all about ADR. Dialogue is. Let me tell you the process of arbitration. Once an arbitrator has been appointed on a matter, he or she has convened the preliminary meeting where the procedural order number 1 has been issued to the party. He or she ceases communication with the parties. That's where you get the role of a registrar or a tribunal secretary. That is business. You see, a registrar gets a job, or a secretary gets a job to that tribunal, and parties only communicate through the registrar or the secretary. The same thing today in modern mediation, we can have secretaries who act like rapporteur of the mediation process. It depends on how the mediator, whether independent or institutional, negotiates with the parties to be able to cut the financial expenses involved in that process. But that we should ensure that the process becomes very cost effective. The next one in the process I will tell you about is trust. Trust is very, very important in the whole process. In mediation, we'll talk about rapport building. You must be able to build rapport with the parties so that parties can be able to communicate, because mediation, not like arbitration, is very emotional. Mediation sometimes brings a lot of emotions, and that's why you see mediation is very, very much friendly, a little bit, than arbitration, because arbitration is just like litigation. It's just like, but private litigation, okay? Where the judge, the arbitrator adjudicate based on what? Remedies. He's looking at what? Remedies, interest, facts in front of him or her. But with mediation, the mediator goes even into other facts, circumstances, intelligence, all those things are being used by the mediator in a mediation process. So one or two more things I will say about the process is about the jurisdiction. You have to know how their jurisdiction, which is very important in the life of ADR. You know that in arbitration, it comes from the contract. If there is no contract or the contract does not state, just a mere inferment of referring to arbitration or mediation gives jurisdiction to arbitration or mediation. And now you can now sit to do what we call in arbitration an arbitration agreement on other components in the arbitration clause. Just the same thing with mediation. So, dear mentees, these were my few comments for you. I want you to be more technical than more theoretical, because let me tell you, within the years, we've seen how a lot of mentees have been more theoretical. And at the end of the day, they keep running again behind us, like they need mentorship, they need opportunities, of which we had already mentored you at Shanty House. So we want this session, and please coordinators, coordinate with them properly. It should be more technical. Today, I tell mentees, if I'll have like over 300 mentees in Africa on different groups, but if you are not very technical, if you go and gather resources and just bring to me, which we know we can get it just with a twinkle of an eye, I will not take you serious. Among mentees, I look at those who are technical, because that's how mentors can even bring you to their firms, to their businesses, to work with you and give you those opportunities that you are looking for. But when you are too theoretical, you are not a resourceful person. So let me allow my other colleague mentors to make their comments. Those were my few comments for you today. Thank you very much.
Thank you so much, Ms. Pa. Ms. Pa is all the way from Kigali, and a Cameroonian, very passionate about ADR, and we are very happy to have you. Always when we call on you, you are always available. Thank you so much. So she has emphasized.
You're most welcome.
Thank you so much for that wonderful presentation. Please, in your presentation, she emphasized, get to know the ADR institutions that conduct um, ADR activities both within and outside. Get to know about the laws, among several other things, and then this is actually an opportunity for the mentees, because some of us did not have the opportunity to have mentorship where we have things like this going on, so we have to find our paths by ourselves. And so some of us may be equipped to guide those who are interested to be guided. Thank you so much for that wonderful presentation. Next, I want to call on my brother, Mr. Isaac Asare. Mr. Isaac Asare, just as he said, is the president and the founder of Africa Center for Collaborative Dispute Resolution. He is in Ghana, very passionate, and we have carried this African mentality. We want to make Africa proud, and we are happy to inform the world that we have vibrant practitioners in Africa that can push ADR forward. And that is why we have people like Mispa and Isaac Asare doing the good works. And we are trusting that we'll be able to contribute our quota. So Isaac, please, over to you. You comment on some of the things that the mentees have said in some minutes, and then we'll move on to another meeting. Thank you very much, Mr. President. Do we have, is Mr. Isaac here with us?
I don't think he is on the call anymore.
Okay, maybe. Okay then. Okay, so let me call another mentor. Mr. I can see Mr. Achi. Is Mr. Achi here with us? Hello? Mr. Achi, are you with us? Josh, is it Honorable Joshua Zaka? Hello, can you hear me?
Yes, that's Honorable Joshua Zaka.
Okay, yes. Please, let's hear from you.
All right. Good evening, everyone, and
Good
thank you
evening.
so much for having me on board the mentorship program. Want to
Just for you
just
put your face.
can you hear me? Can you all hear me? Am I audible?
We can
We can
hear
hear
you.
you.
Can we see your face? Except if you are not in a
Yes, you are.
position.
Yes, I just came in actually. I was on transit. I started when the meeting started, and
Okay.
I'm not really in good shape to put on my video. I'm so sorry
All
about
right, go
that.
ahead. Go ahead.
And I'm also so sorry for joining the program a bit late. Um, well, I just want to say this that we are all mentee in one way or the other, depending on how we look at it. And I want to also comment on the two groups. They've done a wonderful job. They presented wonderfully. That's the good start. Like Mr. Nanchan said, some of us didn't really get this exposure. When I'm back in law school, ours was more of like, how do I put it? It was like they brushed the whole learning about the alternative dispute resolution. And so we were not quick to come on board. But as God will have it, we were able to come on board, maybe much later, depending on how you look at it. But we've been trying the much we can to, let me use the word, catch up. And so we're, like I said, we're all mentees in one way or the other. And then I want to also comment largely on what Miss said. The issues that has to do with jurisdiction, the issues that has to do with what was the word again? Institutions that are on ADR generally. These are things that maybe when you get out there for the mentees, you get to see them practically. But of course, the presentation dwelled more on the theory, but there is also the practical aspect. The practical aspect, you don't have to wait until you eventually come out there to. There are people that you can um, uh, tag along with, and they will put you through. You ask questions and all those things that you need to do to just get the needed skills. But you know, and then the ability to also, like Miss said, give that sharp differences between mediation and arbitration. Arbitration, like you said, is just like a personal litigation, so to say, if you want to call it that way. Because to me, I feel arbitration has some elements of law in it. Maybe that explains for some technicalities. But you see, in mediation, it's it's a free ride, so to say. But you need to understand that there are also elements that you must be abreast with as a mediator. The issues of neutrality, issues of confidentiality, those things are very, very important. You abreast yourself with those issues so that you will not offend the ethics. And so, when you come out, when you get out there, there are you need to get to know these things, and then to help you to sail very well. Like yesterday, I had the privilege also to have um, a mediation session, which hopefully we'll be able to reach a amicable settlement. Now, why am I trying to say this? It has become like a passion, or rather, it's actually a passion for us. We've tested litigation. By the grace of God, I'm on the bench now. And there is this joy that I have each time I refer matters for mediation. And early in February, there was a matter that was referred to the multi-door courthouse here in Kaduna State, and I got the news that they were able to resolve and they reached settlement. So there was the joy of that. It's something that drives you every day, and so you become passionate about it. It's something that you're so passionate about it to the extent that as little issues back at home in your community, you drive for ADR, you push for resolution. So it has to become a part of you. I've seen mediators where to them it's more of like, how do I put it now? It's like a trade, just a trade that whenever I have the opportunity, I put on the clothes or I put on the hat and I go there and mediate. But anything that has to do with my personal being out there, mediation should be kept aside. I think that's not the approach. The approach should be that you put on the hat concerning everything that has to do with you, and so it just flows naturally. So uh, when we're talking about the institutional framework, the jurisdiction framework, and the rest, we need to also understand that you must carry with you a passion. You want to see mediation, you want to see ADR, uh, every given opportunity, you actualize it. So, like for me, in my local assembly, in the church where I worship, it's something I push for all the time. You have people having small issues here and there, and I pursue it. In my courtroom, I champion it. Issues that I know you don't have to go through the length and breadth of litigation, we just suggest or advise people to go for mediation and alternative dispute resolution. Of course, the laws here in Kaduna State um, allows the judge to order for it instead of just suggesting it. So it's something that we just push for it. So beside what I'm just trying to say is that beside the institutional framework, the jurisdiction, and the rest, which MISPA is also emphasized on, because these are things that the mentees didn't really touch on. Besides that, I want to just add that you must have a passion, a drive on a day-to-day basis. So I think that's the much I can say for now. I also want to just quickly say they did a great job, and congratulations, guys, and for the sky is the limit. That's much I can say. Thank you so much for having me here.
Thank you, Honorable Joshua. Honorable Joshua is a judge of the Upper Customary Court in Kaduna State. We're happy that the bench is now embracing ADR. So we have Honorable Dorcas here with us. She has been very, very supportive of ADR in Nigeria and in Africa. Thank you so much. Another interesting person I think we need to listen to is my friend Khadija. Khadija is a lawyer and she works with the Kaduna State Multi-Door Courthouse. So this is where theory meets practical. And I believe that she has one or two things to say to us. Khadija, are you here? Khadija?
Good evening, all. Can you hear me?
Yes.
Good evening to you all. Can you hear me?
Yes, we can hear you.
We can't see you.
Can you hear me?
Yes, we can hear you.
We cannot see you.
You want to see me? Wow. Good evening to you all.
Good evening.
And I'm happy to be here with you. My name's Khadija Kabir. I'm a mediator with the Kaduna State Multi-Door Courthouse, and you have done an amazing job. All the presentations were so nice, and what I want to add on it is that issue of a neutral third party. A neutral third party is really a person who has to have a lot of good qualities. For you to be that neutral, it takes a lot from you. Taking the part of impartiality and neutrality, which is the first thing that is expected of a mediator or a neutral third party, you should know that it's only when you are being neutral and impartial and also unbiased, that is when you will get to have the concentration of your parties, and they would believe in you more and also open up more to you to get it, to understand and get down to the underlying issues. What I mean here by the underlying issues is, firstly, when a case comes before you, because I usually deal with cases directly from where I work, that is the Kaduna Multi-Door Courthouse. I would give you more examples and more illustrations and give you more instances from the cases. And these are live cases which I've handled, or one of my colleagues have handled from our center. So for you being, why it's a very good quality, what I want you to know here is what is expected of that neutral third party. It's more than just beyond, because I had all the groups just mentioning a neutral third party, not knowing that, but I'm reminding you that that neutral third party has a lot of expectations from him. So let's take the mediator, for example, since he is a facilitator, and we all agreed hearing from you that he is not a judge, he is supposed to be impartial. It's only if you are, it's only if you are neutral that your parties, you will be able to trust you and say it all, and they will feel relaxed and at home with you. That is when you will be able to sieve out the underlying legal interest or the underlying issues. The point I'm trying to teach you here is, let's say, for an example, a party might come to you saying, no, this is, I'm here, that you should give me is a 10,000 naira party A. I'm owing party A 10,000 naira, and he has refused to pay me for the past 3 months. So you would see that as you go in the session, you being so neutral with them, and you entering what is called caucusing, because there is what we call caucusing under mediation. That is which we mean a private sessions. We're trying to hold private sessions with each of the parties in relations of trying to know trying to give them and opportunity to see how they would be able to resolve their dispute. So you will be able to sieve out the underlying interest. It might not necessarily be that 10,000 naira. The underlying interest might be surprisingly just saying a sorry or a thank you to the other party. And before you know it, a case of thousands of years would be resolved. As a neutral third party, you are also supposed to be a sponge. What I mean by a sponge here is that you're supposed to be that baby sponge. We know you have different types of sponges. We have the hard ones, and then the soft baby sponges that retain water. So you are supposed to be those baby sponges that you will be able to take in all the frustrations from the parties. It's also expected of you, because here are people coming to you. The parties are coming to you with different types of behaviors, and mostly a lot of them usually come in anger, hoping to even see the other. So your neutrality and treating them equally does not only remains in how you, help them facilitate, but also its extent to even how the certain arrangement it's being done, and also what is even being given to them. Let's say, for an example, you can give party A, you can offer party A a drink, let's say a Coke, and then offer the other party, and then order the other party. I'm sorry.
You are not neutral in this instance. You are supposed to ensure confidentiality. Now you have included that you have third party interfere. Yes. You can go ahead.
Sorry for that interruption. That is the beauty of being a mother. I'm very, very sorry. Actually, they could not miss me for this long. So, however, I was explaining being a sponge, and the sponge that I want you to be as those neutral third party is that baby sponge that you could be able to retain all those frustrations from the parties coming in to you. Then you should also be able to know that that neutral third party should be able to know the difference between empathy and sympathy. You are supposed to empathize with your parties, but not sympathize with them. I know we all know the difference between empathy and sympathy. What I mean by empathizing with them is you being able to understand from where a person or from where his pain is being coming. But if you sympathize, let's say for an example, a party comes to you and say, okay, my husband just slapped me, and you'll be like, what? He slapped you. So you see, you will be compromising the issue of you being neutral, and you're trying to now put yourself in the shoes of that, that particular party, which might make the other party thinks that you are siding with one, the other party. So it's very, very important and key to know that you are to empathize, but not to sympathize with your parties. After that, we should also know that we are supposed to be soft on the parties, but hard on the problem. All these issues that I'm discussing, you should remember that it is what is expected of that neutral third party under mediation. Are you with me, class? Are you with me?
Yes.
Are you with me,
Yes,
class?
ma'am. Well, too, ma'am.
Are you getting it?
Yes, ma'am. Well, too. Yes, ma'am.
Okay. So you should know that there is what we call this active listening that is also expected of that neutral third party. A neutral third party should be able to listen and listen actively. What do I mean by listening actively here is that you should be able to listen to understand, because there's a difference between hearing and listening. So you should be able to listen and listen to understand, but not just to hear them. You should give them a listening ear, and also ensure that ensure that you are indeed listening by, let's say, rephrasing or restating their statement that they are giving you. That is the parties. So the discussions, while I'm giving a little tips on the neutral third party, is that you should know that what is expected of that neutral third party is much. It's not just that you being neutral and that's all. No. You also have to have emotional intelligence. That is, you should be able, neutral third party should be able to recognize, let's say, the change in behavior of one of the parties, or when the room is being tensed and blows are about to be exchanged. You should be able to, perceive that coming. You as that neutral person. So it's not just you facilitating, as you only stated, but you should know that the neutral third party has a lot of work to go on. As we listed, and a lot and etc., so that I should not take much of your time. Thank you so much. Thank you so much for having me here, and I hope you understand it all.
All right. Thank you very much, Khadija, for that. People are dealing with practical. The way they speak is different. And all right, so we are going to come to the practical aspects of both deviation and arbitration. So in the course of the mentorship, and I will be
I hope
happy
you
to have.
understood.
Yes, they do. So we are hoping that in the course of the mentorship, we will come to a point where we are going to be doing practical mediation and arbitration. And
Okay,
I know
sorry.
you'll be
Got it.
there, yes, in the course of the mentorship. So thank you so much, Khadija, for that wonderful contribution. The next mentor I think we call for today will be my very good sister and friend, Deborah Maida Marguerite. Are you here with us?
Yes, I am. Good evening,
Good.
sir.
Good.
I know you would request to see my face, so.
That would be nice.
Okay, I hope this serves. Had retired for the night. Wow. Good evening, everyone. Good evening, Your Worship, my mommy, Mrs. Dorcas Levy Daniel. I love you from here. And love to everyone. My daddy too is here. His Worship, Mr. Joshua Zaka. And thank you, Mr. Nanchan, for this great privilege. I am so glad to be here. I agree with His Worship when he said that we are all mentees in one way or the other. Just depends on the angle with which we are all looking at it. I have personally gained a lot. And time will fail me to talk about Miss Pa from Rwanda. Thank you for those great perspectives that you have brought in. It would help to broaden our horizons, everyone really, to be able to aim higher. And then thank you for not leaving out what His Worship equally emphasized on passion. I am always one that advocates that passion is key in everything that we do. And I'm hoping that you mentees are not just here to do a paper presentation. By the way, a very beautiful presentation. I enjoyed myself listening to you, and I was really glad. I am still glad that I am a part of this forum this evening. The truth is, we are dealing with real life situations, not just some game or some theory or some little disputes that we do in our various homes, and whether we say sorry or not, it's fine, and people just have to forgive and go on. We are dealing with real life situations, people who are going through, who are not enjoying the beauty of the symbiotic nature of humans and why we are made as humans in the first place. We are meant to be people that grow within family circles. And a lot of people do not understand the privilege we have to have fathers, mothers, brothers, sisters, friends, colleagues, and all the people that are, even neighbors. So all this, or even religious crisis that we now have that is tearing us apart as people wasn't always so. It wasn't always so. Now we are allowing a lot of things create a rift between us and the fellow human being who has equal rights or rights with us as we are. And it's just breeding and spoiling and further dividing us. Look at all of us on this platform now. Aside our faces, beautiful, handsome faces, our varied religions, our varied tribes and belief systems, temperament, nature, and who we are. God, who made us all, made us and put us in the same wall. Look at Rwanda is speaking to us. We are all in Nigeria. Perhaps others are in different parts of the state, our country as we speak right now. There's this uniting factor that brings us together, that surpasses your grief, your selfishness, one's ambition or self-drive against that of the other. I say that to say that it is important for you mentees and perhaps all of us to always remind ourselves that we are privileged to sit on the seat where we are either facilitating in whatever fronts, whether you are a mediator, an arbitrator, a negotiator, or a conciliator. I always say, make sure that the way that you are sitting to facilitate over another person's matter, think about it. If you were the person in their shoes and what you are doing now as a mediator or whatever cap you're wearing, if it were done to you, would you be okay with it? That's one. Two, Mr. Zaka talked about passion, and my Khadija, thank you for talking about empathy. That was apt for me too. Empathy, not sympathy. Truthfully, when you sit to listen to people, people lie. Kai, people can lie, people can cry, people can come with all forms of first front personality, and it takes delving in, touching areas to be able to discover what it is the person is saying or not saying. So I liked it when Nispa talked about the fact that a mediator takes it a step ahead and has to go beyond just what is said and delve into other angles, other aspects or events, just to help in the facilitating of that process, to help people come to complain about item A, but they forget to mention B, C, D, E. And it's in the course of mediation that you're able to help even them to be able to pull out or see that they left these angles hanging, or these matters that are also pertinent or important to the cases that they are sitting down on. It's beyond what is said. It is looking at the body language, looking at the eyes, looking at basic verbal and non-verbal communications are clues. They are keys that we have to always pay attention to when sitting down with people. But above all, realize that these people are people and they just need our help. So I liked when Madam Khadija mentioned caucusing. Sometimes it's important to have caucusing and help these parties to understand the pros and cons of why they are there, to understand what the consequences of their issues and decisions are if they don't go this way, or that way. You're able to also hear them deeply. They're able to open up and speak to you. And that's where you're able to even find out, in all honesty, what they were truly looking for was, I am sorry. Not that they wanted to press charges or push this matter to any levels, or just come out and say, oh, I lied. I didn't mean it this way. I always did this. I'm a manipulator. They just wanted a confession, not anything else. We've seen cases where parties, is this what you were trying to say all this while? I didn't understand. You should have, I said, but I have been speaking. Where was your ear all this while? And they end up leaving the center, holding hands, laughing and smiling, and grateful that they came. I remember times I'd received gifts from my parties at the end of our sessions, of our settlement terms. When we finished, I'm just sitting there and I see them giving, someone said they brought, and they enjoyed, because we were able to enlighten them beyond even the matter on ground. And we're able to establish friendships with them eventually. So it's for me a joy that people are able to trust you enough to open up, because it's difficult to open up if you don't find people that you trust, people that are truly vested in your matter and are passionate too about helping you to find a direction, a solution. It may just enter and go out, but these are matters you go to bed thinking. So my counsel tonight, I will not belabor what has already been said to you as mentees, is as you come up on board, it's important for you to realize that your passion is key, your ability to be compassionate, and then be hard on the problem, not on the parties, because you will see them outside places. We must still try to maintain confidentiality, keep their stories safe, let them still know they can reach out to you, they can trust you, you can be of help to them, and then you be professional about it, because there are some parties that could be so pessy and call you middle of the night, call you in the morning, call you in the afternoon, or just keep trying to. Sometimes people just ache, they are traumatized, they need help, they need some level of sympathy, or empathy rather, not sympathy. They need some level of listening ear, because you become the shoulder they're able to lean on. My prayer for us and many more that will join this van, this wagon, or this what ride will we call it now, is that as we come up on board, let's realize that the nature we are in is one that involves another person and another person. Whether inter or intrapersonal relationships or conflicts will always arise, and it's important that we're able to be that shoulder that people can rest on, can trust, and can rely on to be able to find alternative ways to solving their personal or interpersonal problems that comes. I love you all already, and I'm truly, truly blessed to be here. Thank you for this wonderful presentations from you mentees. I hope that you're able to take to heart all that has been said and even more. I know that perhaps most of the suggestions or advice we're giving, you've heard them before, but then it's never too much. It's never just too much. Thank you to Shati House. Thank you, sir. Thank you for
Thank you, Deborah, for that wonderful contribution. One more person before we close this session is Queen Esther. Are you here? Let's just hear from you, and then we'll take 2 questions, and then we are done.
All right, good evening, everyone, depending on where you're listening from. My name is Queen Esther, just as my boss, Mr. Nanchan, rightly said. It's such a privilege to be here. And my sincere greeting, Mr. Apologies, please. I may not be able to turn on my camera because there is no, because of lack of supply. Thank you very much, sir. All right, my profound greetings to other mentors here and to the mentees right here. First, I'll begin by saying congratulations, because this is actually a program that you will so be equipped with the tools that you need for what you have set to achieve and all. And just to pick up from where Ma'am Deborah just stopped concerning passion, I will say that the work of a mediation has to do with the passion. You have to be passionate towards seeing that people get their conflict resolved. Fine. Yeah, there are times when people may not have a solution at that point, but the fact that you're able to get them to communicate their thought at a particular instance does a lot of things as it pertains to that conflict or dispute. Now, still talking about passion, I remember when I had to be with Mr. Nachan sometimes in October. You'll find out that as a mediator, you have to be very patient, very patient. Patient is one of the attributes that any mediator or anyone that wants to venture into this practice, you have to be patient. Aside being passionate about seeing people resolving their dispute, you have to be patient. You have to have that space, because sometimes if you're at the mediation table, a lot of things could happen. People could get so bottlenecked, they don't want to shift ground and all. But as one of the key attributes that a mediator should have is that gift. I'll call it gift of patience. I remember on one mediation table, I was like, why are these people like this? That we should just go and sign the report in the multi-door courthouse and say these people don't want to settle. But because of the way Mr. Nacha handled that, I was like, God, what is really happening here? That it takes, because for me, at the point, I was like, if these people don't want to settle resolve their dispute, they don't want to make headways, let's just go and give the report that these people don't want to resolve, and that's all, so that they want to go back to court and continue the proceeding in court, fine. But then, because we know that there is a goal, there is a particular goal to which that process, to which you are called to be. Because I see mediation, for me, I see it as part of purpose, that is as a calling, right? So first of all, you have to be, just like Ma'am Deborah said, you have to be passionate about what you are doing, and you have to be patient. You have to be patient as a mediator. If not, many things that will have been resolved, if only you're patient, you find out that you abort a lot of peace, especially when it comes to family disputes. Maybe you're the tool that God wanted to use to actually mend this family, mend this shattered home. You find out that you are now a factor that will not even elongate the process. So as a mediator, passion is very important, because that is where it will stream from. Passion is what will give you the staying power to make you to even look, okay, what are the necessary means? It makes you to think deep, to ask more questions, to be so concerned, like you said, and being empathic. I'm sure they've mentioned before you came, most of the characters of mediation have been mentioned. So all those words, but very importantly, passion and patience. So I'll be cutting the curtain from here. Like I say, it's a great privilege and a honor for me to be here. Apologies for not seeing my face. I believe by tomorrow I'll be able to get past supply and I'll be able to see another person be able to see my face and also to be able to see people's faces who I can't actually see right here. Thank you so much, Mr. Nanjan, for this privilege. God bless you. And God bless everyone here. Thank you so much.
All right, so our time is fast spent. I will just give little time for some time for I don't know if there is anyone among the mentees who has any question or needs clarification. Please, you can raise your virtual hand. You can drop question on the chat box, and or you can raise your virtual hand, and then you'll be allowed to speak. Questions? Okay, I can see one of the, well, if you have question, raise your virtual hand or drop it on the chat. I can see Jennifer. Jennifer is here. Please, do you have something to say? Just 1 or 2 minutes. Oh, good. We have some questions here. Jennifer, just 1 minute before we.
Good evening, sir. Good evening, everyone.
Good evening.
Hello. Good evening, everyone. It feels good to be here. I'm so sorry I have not been online all this while. My phone started acting up and I had to switch it off and charge it a bit. So, but now I'm back. Thank you all for having me.
All right. So, do you have anything to say in respect of the aspects you have heard from the mentees? Just 1 minute.
Okay. I don't have much to say now. I think when I logged in, when I came back online, I heard one of the mentors talking about you being patient and all, so that you don't scatter what you were meant to mend. And one thing I would love to say is that after I went through my class as a mediator with Shati and KDMDC, that's Kaduna State Multi-Door Courthouse, I learned to be more patient and tolerating and accommodating, because we were told that as a mediator, you shouldn't be even caught exchanging words with somebody. You're meant to be an ambassador of peace. So I think I should just add that you are meant to be an ambassador of peace as a mediator. So that's it. That's all I can add tonight.
All right. Thank you very much, Jennifer. So, in essence, what Jennifer is saying is that the mediation cap or the ADR cap is not something that you just remove and keep, and then afterwards you fix it up. We should try as much as possible to make it part and parcel of our lives, because we may not be able to distinguish between the two. All right, so we have a question here. The first question is, what is the practical difference between enforcement or settlement agreements reached in mediation and an arbitral award, especially in terms of possible grounds of challenge? I think I would like to call on Honorable Dorcas, who is versed in both mediation and negotiation. Okay. Honorable Dorcas, are you here? If you can attempt this question for us. The question is, number one, what is the practical difference between enforcement of settlement agreements reached in mediation and an arbitral award, especially in terms of possible grounds of challenge. Is Honorable Dorcas here? Yes, he's here with us. Okay, Mr. Isaac.
Yes, I'm here.
Oh, thank you. Thank you so much. So that's the question.
Yes.
Do you hear the question?
Yes, thank you. The first question, right?
Yes, ma'am.
Okay. For settlement, what is the practical difference between the enforcement of a settlement agreement reached in mediation and an arbitral award, especially in terms of possible grounds for challenge? Of course, for settlement agreement, we know is basically enforced as a contract, as an award between parties. It is, while an arbitral award is a decision of an arbitral tribunal. So the parties actually agree to the settlement agreement, to the terms contained in the settlement agreement. While for the arbitral award, it is a decision of an arbitral tribunal. Most times when there's when issues of enforcement come, when the other party does not agree to the arbitral award, they will have to go to court for the court to enforce the decision made by the arbitral tribunal. While for terms of settlement, it's the same thing. If one party fails to do his own part of the agreement, they will have to still go to court for enforcement. Now, the law is that parties are not, for settlement agreement, a party is not allowed to blow hot and cold. Whatever you append your signature to, whatever you agree to as terms of settlement remain terms of settlement. However, the challenges can come when there's fraud, when there's coercion, when there's misrepresentation, and when there's a mistake. Those are situations where parties can actually get to have those terms of settlement set aside. And of course, that requires filing almost like a civil proceeding to set aside these terms of settlement. While for arbitral award, when it comes to issues of enforcement, it is only, an arbitral award is only set aside on limited grounds of lack of jurisdiction, public policy, illegality, and misconduct on the part of the arbitrator. So those are basically the practical differences, but they involve going to court to actually have both terms of settlement and arbitral awards enforced by a court of law where one party fails to do his own part.
Thank you so much, Honorable Dorcas, for that answer. That's question number one. So, and you should know that where there is settlement agreement, parties are not allowed to go and set it aside. You know, once you have agreed and it's confirmed, that is it. In fact, most times, even when you go to court to try to set it aside, you know, you may just end up incurring costs on yourself, you know, depending on the jurisdiction. And then arbitral award basically comes from arbitral proceedings where either an individual arbitrator or a panel, you know, gives their decision concerning what was brought before them. So that's the difference, as your Honor has said. Number two, the second question here is to what extent has the adoption of ADR mechanisms improved the efficiency of business dispute resolution and community peace building in Nigeria? Okay, so with this, I will ask Mr. Isaac Asare to attempt that question and also give us his own perspective as a mentor. Mr. Isaac.
Okay, thank you, Danchan. And let me congratulate all the groups for the good job that they have done Sorry, I've not been able to be with you all the time because I have a class. I have to put them on break so that I can have some small time to join you and go back.
Thank you so much.
Thank you for the question. When it comes to the how ADR is helping to keep business relationship and also community, when it comes to litigation is about one party wins, the other party loses, and the adversarial nature of it does not help to build good relationship between communities and also individuals or businesses. For instance, if I'm your business partner and I have an issue with you and you take me to court and you win the case and a judgment is enforced against me, you think the relationship between us will be better? We will not have a good relationship. But if we are able to settle the matter through mediation, and we are able to come out with terms that we agreed upon, and maybe even if I'm owing you, we have been able to spread it over time for me to be able to pay and to have that lean way of paying, which is more helpful to my business and also to your business, so that we can still continue to keep the business relationship. And also in community, imagine taking a neighbor to court. After taking the neighbor to court and getting judgment against the neighbor, what do you think will happen between you and the neighbor? Although you have won, but what about the relationship aspect? How do you deal with that such situation? So you go to a certain community, some houses and the other houses, their eyes does not meet and they cannot have anything in common, because they even want their children not to have anything to do with the other people. So that is why ADR is there. If we have an issue, particularly with mediation, why don't we get a mediator which help us to repair the broken relationship and to build a future that helps in maintaining a sustainable social cohesion within communities. And that is why ADR is particularly good when it comes to community issues, when it comes to business relationship, simply because you will need somebody tomorrow, and it's important to keep good relationship. So ADR is good, and it is important for us to understand, learn more about ADR, and to be able to exhibit what ADR can do to assist people, and we must be able to understand it well. It's a good question that you people are asking, which is very good, and this shows how you are prepared to launch yourself within the ADR practice. And it is important for you to learn more, know the differences between arbitration, mediation, and negotiation, and other forms of ADR, so that you are not like the normal person on the street. You don't mix the processes. So you don't mix them. So you make sure that in negotiation, there is no third party. I think I heard the first presenter, I heard you mention about negotiation. Even if someone is involved in negotiation, if Nanchan has an issue and he is going for negotiation and I follow Nanchan, I am not a third party. I am an agent assisting Nanchan through his negotiation. So I don't become a third party. So in negotiation, there is no third party. And that is what you should understand, that when it comes to negotiation, there is no third party. And when you introduce a third party, it becomes assisted negotiation, which is mediation. So these are the things that we want you to take note of and be able to learn more on it. I think my time is up. I'll pause here and run back to continue my lecture. I hope to meet you next week. Maybe that day I will not teach, so I can have more time with you. Thank you very much.
Thank you so much, Mr. Isaac. Thank you, Mr. President. Sorry, Mr. President. Pardon me, please. Thank you. Yes, I saw our mommy, Honorable Dorcas, maybe is still with us, and she will help us answer maybe the next question. To what extent has the adoption of ADR mechanisms, okay? Yes. How does ADR promote peace and social harmony in community land disputes? So, Honorable Doctor, if you can just 1 minute attempt this question, then I'll call the others.
Okay.
And
How
I
does
think you should help
ADR?
us answer question 3 and 4. How does ADR? I know some mentors have touched on it. You just pinpoint a nail on them. Answer: why is conciliation particularly suitable for labor, customer, and government-related disputes?
Oh, okay. How does ADR promote peace and social harmony in community land disputes? That's because most land disputes actually take a long time. You wouldn't want to be involved in a land dispute because land disputes, we have found out, take, okay, yes, it may affect my network a bit, but that's okay. Okay, so land disputes actually take a long time to settle, and they usually involve neighbors, they involve family, they involve the community. Now, that's why there's need for ADR. We have said it before. If you take your neighbor to court, you wouldn't want to come back and remain friends. Your neighbor wouldn't want to be friends with you. Now, ADR promotes peace and social harmony in such land disputes because it helps them to resolve the disputes fast, less cost, it is timely, friendly settings, and then everybody gives his opinion. People come and lay their terms and express themselves. Some people actually just need to vent. So that's why ADR is key. If you go to court over land matters, I am coming from the bench as well. I know how long it takes for land matters to be resolved. 30 years, 40 years. There are matters that have lasted 15 years, 16 years, which have been resolved in maybe 2 sessions at the multi-door courthouse. So ADR promotes peace and social harmony because it restores relationships, preserves relationships. The time frame is not much for resolving of disputes. And then it's less costly. And of course, peace and social harmony is what everybody wants. We've had communities come against each other with daggers. They've come to fight. But ADR has helped them to resolve these disputes in a matter of days. So of course, ADR promotes peace and social harmony within the community. They live shaking hands. They live as friends. That is how important ADR is to land disputes. Then why is conciliation particularly suitable for labor, consumer, and government-related disputes? It is suitable because it's only in conciliation that you can actually make suggestions. You can suggest options to the parties. In mediation, you cannot make suggestions of options to the parties. Now, everybody comes in government-related disputes, everybody comes with shoulders, they come with their ego, they come with their power, they come with what they feel is right already. But conciliation now gives you room to suggest options that will be useful, that may come in needful for the parties. For labor disputes, right now in Kaduna State, JUSUN, Judiciary Union, is having a dispute with the government, okay? Nobody wants to listen to the other. But when you come in as a conciliator, you have options that you can make known to the parties for them to choose from that will help in resolving the dispute. The consumer are coming with bitterness, consumer disputes. Somebody feels hurt. Somebody feels, no, you're looking down on that person. Somebody feels, no, you're not being respectful enough. But because you have options that are open to you, you'll be able to suggest to the parties and they can adopt those options. Unlike, say, mediation, where your duty is to just facilitate settlement. It's about the parties. The parties have autonomy. They decide what happens in mediation. They bring their options. Conciliation, on the other hand, gives you room to actually suggest options to the parties. So I think that's why conciliation is particularly suitable for labor, consumer, and government-related disputes. Thank you so much, Anta.
Thank you so much for that wonderful answer. Thank you. So quickly, is it necessary to become certified before you become an ADR practitioner? Uh, I don't know if Honorable Joshua is in the house.
Yes, I'm in the house, sir.
Can you
I'm
just
still here.
quickly, yes, just in some seconds, can you attempt that question?
Yes, before you become a practitioner, you must be certified. It will it will negate or go against what it stands for if everybody is just allowed to go about his business the way it's. So there must be a streamlining, and that is why the certification now comes into play. So yes, you must be certified to become an ADR practitioner anywhere, anytime. I think that's that what I can answer for now. Thank you very much, sir.
Thank you. Thank you so much. Is Miss Pa still with us? Okay. Miss Pa is not here. Okay, so uh can I okay. Let me just add something quickly. You see, let me beg to add my own idea too. In as much as some of us are coming from institutions that train and certify ADR practitioners, I will need you to understand that for the person who asked this question, you need certifications, but not necessarily to become a mediator. Not necessarily to become a mediator. And what I mean is that we have people who have this inbuilt ability and capacity to help resolve disputes, and they are not trained or certified. Sometimes you see our pastors, our imam, our traditional rulers, our meangwas and the rest of them, they do some of these things, but they do it in an informal way. And so you can actually help resolve disputes in your community, around your environment, in your workplace. You may not necessarily be a certified person. But if you want to operate in the professional space as a recognized EDR practitioner, that matters will be assigned to you and you'll be called upon, you'll be appointed and you'll be paid, you will need to get certified. The certification is a testament to the amount of knowledge you have consumed, amount of expertise and dedication you have put in to be able to build yourself to a place where people can actually trust your ability. And when at the point of choosing who will be my arbitrator or mediator, sometimes the parties will want to look at your level of expertise. So imagine you have someone who knows so much about how to do the house. To myself. Are we together? Hello?
Yes. Yes.
Yes, we're here.
Okay. I said, okay, so, okay, that's the difference between a merchant and an engineer. An engineer will get the contract and will collect the millions, while the merchant will be called upon to do the real work, and then you'll be paid a peanut. So when you get certified, you position yourself as an expert in that field. but it does not necessarily mean that you cannot help in resolving disputes at your own level. That's just to add to what Honorable Joshua has said. If you want to be a professional recognized in the field, you will need to get certification. And the certification is not just one certification. You want to get several certifications so that you can be recognized as an industry expert in that particular field. All right, thank you so much for that contribution. And then quickly, in arbitration, when there are controversies or a valid grounds to challenge an arbitral award, a party may approach the court to set aside. In mediation, since the outcome is voluntary, what mechanisms ensures compliance with the settlement agreement? Please, if you are not speaking, can you just mute? Okay. So now, where settlement agreement means parties have met, discussed, and have agreed, and they go before possibly a judge, or if it is in a multi-door courthouse, maybe where there are ADR judges, that has been stamped. Before that agreement will be stamped and it becomes consent judgment, the judge, the ADR judge or the judge in the court will want to ensure that he confirm from the parties whether or not the agreement expresses their wish, their desire, and their decision. And if they are not coerced into, once that thing is agreed upon and is confirmed and the judge signs it, if it is in a court, he will adopt it as his own judgment, meaning that you can actually enforce it. Now, where you have terms of settlement just made between parties who can own to the content, you can actually take that as a lawyer. You know that you can take that before a court, possibly that has jurisdiction, maybe file a matter, and then on the day of mention, you tell the court that parties have actually resolved their disputes and the parties can actually the judge will adopt the terms of settlement as his own judgment, and you can enforce it as the judgment of the court. Meanwhile, the AMA, the Arbitration and Mediation Act, now says that settlement agreement can be enforced in court as either consent judgment or consent award or um, contract between the parties. So that gives the backing. So you cannot say now, mediation has no force of law. No, the law has clearly stated it, and it can be enforced like the judgment of the court. So that's one thing that you need to take note of. You need to take note of that. Finally, okay, although ADR is praised for its reputation for preserving relationships, are there no situations in practice where disposition or perception of the parties may hinder the effectiveness of ADR process and go on to scar their relation? May go on to scare hinder the effectiveness of ADR process and go on to scare their relationship. And as an experienced ADR practitioner, what do you recommend to mitigate the risk? Now you see, ADR is not a process that you compel parties to ADR is not something you compel parties to do. So where parties are not agreeing to the process, you cannot proceed. That's one thing you should understand. But in the process also, you may have difficult parties or you will get to a deadlock. These things we are doing are just peripheral. We are just trying to give you an understanding of what it entails. If you are interested in getting more understanding, you have to enroll for a certification, of which we know mentees from this program are actually giving some consideration when you want to get certified as a mediator. Resettlement House ADR Training Institute. So that will give you a very foundational understanding of how these things work. So, but will you get difficult parties? Yes, but ADR practitioners are trained to be able to navigate through those things. And one of the things you can do is, understanding of your emotional intelligence and how to apply them with parties, understanding your personality types, different personalities and how they display and behave. And another thing is the use of caucusing or shorty mediation. These are some of the things that you need to explain in details when we are doing a proper certification training, but this is mentorship. But be rest assured, these are some of the things that you need to do. For want of time, that's why I have to just go through this. Although ADR is pressed, yes, I've answered this. And then, yes, immediation, yes, I've answered this. Okay. I think basically we have answered some of the questions, except if there is any question that has not been answered. I don't know if there is anyone among the mentors who may want to just say one or two things, just briefly in 1 or 2 seconds, in respect of some of the questions that I've said, especially someone who has not spoken before, that will be fine. Is there any other question or any comment? All right. Okay, so I will want to at this juncture thank you all the mentees for actually being patient and staying to this time. And the mentors as well, I want to appreciate you for creating time and staying to this time. That's very, very huge. 3 hours, almost 3 hours out of your time is not actually a play. I have people who 1 hour is a lot of money to them, but they created time to be here. That is to show you how that's to show you how devoted and committed these facilitators to giving their time to put in, and invest on your own life. So I hope that next week we are going to have more of the mentees come in. It will not be good for all the mentees, about 40. We're expecting about 40 there about, the mentors have suspended some of the things they are doing and they are here. We're expecting that you create time and dedicate time and take advantage of these things. Some of the things you are learning, I tell you, you pay a lot of money to do a consultation with some of the mentors, but they are here for free to offer you that. Please don't throw it away. Next week, create time, charge your gadget, prepare them, and then ensure that you stay from the beginning of the mentorship through the end, so that you can get whatsoever is meant for you. Thank you so much for that, and I will pass it over to Mr. Um, I'll pass it over to Mr. Dennis for an update. Thank you.
All right. All right, sir. Thank you so much for your very, very kind words. A big thank you to all the mentors that came on board and shared their thoughts throughout the course of the class. Like Mr. Nyacham said, this is just the introduction part, right? This is just the first class. We still have more mentors we'll be sharing in the subsequent classes that right? Please, it is not earlier, but because of the issues, I wanted us to really just get on with class as much as possible and not necessarily delay in taking pictures. So please, if you have your camera, if case that has lighting and you can turn on your camera, your video on, please, can you kindly do that? Let's take a quick picture, right? We will just do that in 1 minute and then we'll call it a night. So please, I want to call on both mentors and mentees. Please kindly do well to turn on your camera. I can see our mentors are turning on their camera. We really, really appreciate you for doing this. So please, mentees, you should also cooperate. Turn on your videos. Let's take a quick screenshot. Thank you.
Can you imagine the
so,
beautiful faces
I'll
behind
be
the
doing
camera? Wow, this is interesting.
All right. So we're still doing that. Sorry, we'll be done in a minute.
If you are in the system, you can help us snap as well. Please just hold on a minute. We want to use a more just a minute.
All right. Thank you very much. We are done. All right. Thank you very much, everyone. We are done with that. Once again, a big thank you to everyone who was able to make it to class. Please do also, for the mentees, we would be sending next research to your group later before the end of this evening. Please do not forget to share what you have learned on your different social media platforms, or you can tag JIIPCC as well as Shati, that is Settlement House Training Institute. You can search for us on LinkedIn, right? And you will find us JIIPCC and Settlement House ADR Training Institute, Shati. You'll find both platforms or both organization on LinkedIn. Tag us, mention what you have learned. Like I said, this is just the first week. There's so much more that we have in store for you. And I hope the learning experience will be worth it at the end of the program. So thank you all for being here. See you all next week and enjoy the rest of your evening.
All right, thank you. See you. Bye.
Thank you, Dennis. Well done.
Thank you, sir.
Bye.
Have a